As we've discussed, a person who is sentenced to death, who has raised their appeal their case and lost in the state courts, has gone to the state courts in post-conviction proceedings, lost there, the last hope for that person is to file in the United States District Court for wherever they're from, appeal to the United States Court of Appeals under federal habeas corpus. And as we have talked about, the courts have restricted the availability of habeas corpus. Justice Brennan had a very wide view that habeas corpus should be available as long as the person didn't intentionally bypass the state procedures. But soon after that, Justice Rehnquist tightened that up a great deal and said unless the person complied with every procedural rule, raised the issue at the right time at trial, raised the issue on appeal, gave the same constitutional arguments there that are now being asserted in federal court, the federal court would not look at that. I want to talk just a little while about how the federal statute was amended in 1996 to restrict even further review of state death penalty cases by federal courts, and then talk just a little bit about the standards of review and the burdens of proof that courts utilize in deciding these cases. 1996, the habeas corpus statute was amended in a number of ways, and I'm only going to talk about a couple that are particularly important. There are others in the materials that you can look at, but these are the ones that really made a huge difference. First of all, a one-year statute of limitations. There had never been a statute of limitations on habeas corpus in the history of the country. So you had people who might have been in prison, let's say in a non-capital case like Reuben Hurricane Carter, if you've ever seen the movie The Hurricane. He didn't get habeas corpus relief until 20 years into his sentence. Many other people often later in the time that they had served would find lawyers who would work on their cases, or they'd finally figure it out themselves in the law library and they'd get relief. Now, 1 year. Once the case is final on direct appeal, the person has 1 year to file in federal court. If they go into the state courts in the state post-conviction process, the time will be held for the time they're in the state court. In other words, if they wait 6 months and then file a state post-conviction application, and that's litigated through the state courts for the next, say, 2-3 years, when that is final, when the state Supreme Court has finally ruled on that, then the person has 6 months left. And of course, if you wait until the last minute, you can be in big trouble there, and some lawyers have missed the statute of limitations. In fact, quite a few people have missed the statute of limitations, even in death penalty cases, costing their clients any review whatsoever of the case by the federal courts. The one thing important about the federal courts is that the state court judges, as we'll be discussing later, are elected. The capital cases are very controversial cases. It's often virtually impossible for a state court judge to be able to stay in office if he or she grants relief in a death penalty case. The federal courts, federal judges are appointed for life. And for a long time, before 1996, in reviewing these cases, a number of federal courts had granted the writ of habeas corpus, finding that there were constitutional violations. Congress tried to change this and did change this significantly in 1966. They amended 28 United States Code 2254D. That's the paragraph that says what the court can do when a habeas corpus petition is filed and the court examines it. The court can grant the writ if the state court decision was contrary to or involved an unreasonable application of clearly established law as determined by the Supreme Court of the United States. This is a huge change because before, when a federal court ruled on a habeas case, it made its ruling based upon what it viewed to be the correct determination of constitutional law. And it didn't necessarily have to depend upon a United States Supreme Court decision. It may be that there was an issue that hadn't been decided by the United States Supreme Court. Those kinds of issues can no longer be considered because the state court has to have been unreasonable in its application. So the federal courts no longer decide were they right or wrong on the constitutional issue, just a pure question of law. Did they correctly apply the law? but were they unreasonably wrong in applying the law? The first clause here, the contrary to clause, the court said a federal habeas court may grant the writ if the state court reached a conclusion that was the opposite of a Supreme Court decision on a question of law. In other words, the state court decided a case differently than the Supreme Court had ruled on really the same facts or indistinguishable facts. The other clause, the federal court granting the writ under the unreasonable application clause, is the state court identifies the correct legal principle of a United States Supreme Court decision, but unreasonably applies that principle to the facts of the petitioner's case. In other words, the state court recognized that the legal claim is governed by the example Justice O'Connor gives in the Williams case, Terry Williams out of Virginia, gives the example of the state court identifies that this is a claim of ineffective assistance of counsel, violation of the right to counsel. It's governed under the Supreme Court's decision in Strickland versus Washington. But the court might unreasonably, the state court, might unreasonably apply Strickland to the facts of that particular case. This is probably where the federal courts have more room in terms of examining federal issues. Sometimes they'll say the United States Supreme Court case required that all of the relevant factors be considered, and the state court didn't consider some of the relevant factors, and therefore it was an unreasonable application of the federal law. But the mere fact that the federal court thinks that the state court got it wrong is not a basis for granting habeas relief. This is very deferential to the state courts. And so what it means is that it's going to be much more difficult, and habeas corpus, I mentioned in a previous discussion, much harder to get, almost impossible to get evidentiary hearings now in federal court. So the combination of the federal courts not being able to have evidentiary hearings, take evidence, consider that, make findings, instead having to defer to the findings of the state courts and even defer to the legal conclusions reached by the state courts is greatly going to limit and does limit federal habeas corpus review. But we'll see this language in some of the cases that we'll be looking at in the rest of the course. I want to turn to burdens of proof and talk about the different burdens of proof that courts have adopted, just because very often in a case the court will decide, first of all, what does the person have to prove to prevail on the claim? And then secondly, what is the burden of proof? And then thirdly, who has the burden of proof? Because if the burden is very high, the person who has the burden is going to lose unless they are able to meet that burden of proof. So how the courts define, these are not things that are in the Constitution. These are things that the Supreme Court decides in decisions in cases that come before it. Of course, everyone is familiar with beyond a reasonable doubt. In criminal cases, you have to prove that the person is guilty beyond a reasonable doubt. If after hearing all the evidence, you have some reservation, some doubt about whether this person is guilty or whether this fact is true, then the government has not met its burden. The prosecution has the burden of proof beyond a reasonable doubt, and the requirement would be in that case to enter a verdict of not guilty. So that's our highest standard of burden. In civil cases, the burden is preponderance of the evidence, just more likely than not. If you put the evidence on a scale and you weighed the scale, if it's more likely than not, it's by a preponderance of the evidence. Again, who has the burden of proof? If the side with the burden of proof, let's say the evidence is in equipoise, you can't say one way or the other, then the side with the burden of proof loses. So how you allocate the burden of proof is going to be very important. Now, in between these two levels is clear and convincing evidence. That means that the court reasonable, substantial, and probable that the fact that you're trying to prove occurred. So sometimes the courts will say you have to prove something by a preponderance of the evidence, but in other areas they will say it has to be proven by a little higher level, by clear and convincing evidence. And of course, reasonable doubt, for the most part, is limited to cases involving guilt or innocence and the prosecution's burden there. Now, there's another burden that's a little less than this, substantial probability. Is there a substantial probability that whatever happened affected the outcome of the case? That means not enough to be more likely than not, but enough to undermine confidence in the verdict. And we'll see that the court adopted the substantial probability test in a couple of areas as part of the question of whether there's a constitutional violation or not. But again, as we sort of look on the scale of these have to do with the degree of certainty. We were very certain when we say beyond a reasonable doubt. We're pretty certain, but a little less certain when we say clear and convincing evidence. We're more likely than not certain when we say preponderance. When we say substantial probability, we're talking about undermining our confidence in the outcome, feeling not totally comfortable with the outcome. So that's a little lower standard. And then finally, probable cause, which just means probably. In other words, when a police officer goes to get a warrant to search a house, they'll say, here's what we've been told, here's what we think is in the house, and the judge will say, if it looks like it's probably there, then the warrant will issue and the person can go out and seize the or conduct the search, and if there is anything there, seize the property. The same thing for in preliminary hearings after a person has been arrested. The standard is just, is there evidence to say that they probably committed the crime? It's a very low standard, but it means that there is some evidence indicating that the person committed the crime, or some basis for conducting a search of a house or of a person, or some basis for issuing an arrest warrant. But that's the lowest of these standards of proof, these burdens of proof that the courts have adopted. When we get to appeals, which many of the cases we'll look at are going to be cases on appeal, one of the questions to look for in these cases is what exactly is the court reviewing? And they fall into three basic areas that I want to just discuss for a moment. Questions of fact. Is the court reviewing factual determinations made by the trial judge? In other words, credibility of witnesses. Whether a juror can be fair and impartial. In the Ricky Rector case, the judge was looking at whether Ricky Rector was mentally competent or not. And there were expert testimonies on both sides. Expert testimony on both sides. The Arkansas Supreme Court said the evidence is hopelessly in conflict, so we defer to the trial judge, because the trial judge saw the witnesses, made determinations of credibility, and therefore we're going to defer to the trial judge on that, and there's not much left for the appellate court to decide as long as the trial judge applied the right law, that is the law of competency. By the same token, the courts have looked at juries, determination of whether a person can be fair and impartial. The parties are selecting a jury. A person knows about the case because of pretrial publicity. Knows a whole lot about the case, as it turns out, the more that person's questioned. And at the end of the time, the defense lawyer moves to strike that juror and says this person can't be fair and impartial. The Supreme Court has said that's a factual determination. So that the appellate court will defer to the trial judge unless it was clearly erroneous. And so that's going to be a higher standard for the person challenging the juror to overcome in order to win. On the other hand, we have just pure questions of law. Is the death penalty appropriate for people who are intellectually disabled? That basically involves the question, a pure constitutional question of what the scope of the Eighth Amendment is and whether it prevents. So that's a case that the appellate court or the Supreme Court of the United States in this case, is going to decide without much deference to the trial judge, or without any deference to the trial judge, because it's a pure question of law. Whether the due process clause requires, say, a hearing or requires notice in a particular situation. This, again, is going to be a legal question, and so an appellate court will decide that and be pretty much free to decide what the law is and then apply it to the facts. And then what we often have are mixed questions of law and fact. The question of ineffective assistance of counsel involves both the law with regard to what the Sixth Amendment right to counsel guarantees a person, but it's also intermeshed with the facts of what did the lawyer do in that particular case, why did the lawyer do it, and so forth, which we will talk about more when we talk about the right to counsel. But so, depending upon which of these general areas the question fits in, the appellate court may or may not have a more vigorous role to play. Almost complete deference to the trial judge. If it's a factual question, the court's going to be able to do whatever it wants. If it's a question of law, it's going to try to determine the constitutional law. And then finally, if it's a mixed question, the court is going to try to distill out what are the facts, which we still defer to the trial judge, but what are the legal questions which the court is going to decide. Related to this is that what standard does the court apply in reviewing these various questions that I have described? De novo review, the appellate court decides, examples I gave before, what the Constitution, what the statutes, what the rules are, and then applies them to the facts of the case. Clearly erroneous, as I just mentioned, the appellate court is going to defer to the trial judge with regard, say, to whether a potential juror could be fair and impartial. If the juror goes back and forth, again, we see this with the question of could the juror fairly consider the death penalty? A juror may, well, I don't know if I could do it. Well, I think I could do it. There's a lot of going back and forth. Ultimately, the judge allows the juror to sit. Appellate court looking at that, if that's claimed to be error, is going to defer to the judgment of the trial judge unless it was clearly erroneous. The court feels very clearly and strongly that the trial judge made an error. Finally, abuse of discretion standard. This is for the one challenging, the appellant who's challenging what a judge did. This is the hardest to overcome. Judges have a great deal of discretion for all sorts of things, like whether to grant a continuance or not. One party says, we're not ready, we need more time. The judge says, I'm setting the case for a certain date. Almost always, that is going to be upheld by an appellate court. All sorts of other administrative or rulings that the judges make, admissibility of certain evidence is judged by an abuse of discretion. Not always, but sometimes. But the take-home story here is if you're appealing and the standard is abuse of discretion, it's going to be very difficult to prevail. It's going to be also difficult on clearly erroneous, much less so on de novo review. So a lot of times the argument in a case will be, what is the standard of review for this particular case? Because if it's one or the other, it may determine how the outcome of the case. But then the question, what if there is an error? The court finds that the Constitution was violated in some way, but does it make a difference? At one time, the rule was that if there was a constitutional violation, the case was reversed and the person had a new trial. But today, the courts employ harmless error standards in order to often affirm convictions and affirm death sentences, even though there was error. The highest standard, again, this is our highest standard of proof here, harmless beyond a reasonable doubt. Chapman versus California, the Supreme Court held that even a violation of the Constitution of the United States could be harmless if the court could say, we are confident beyond a reasonable doubt that this did not affect the outcome of the trial. Of course, it's very difficult for judges to do this. They didn't see the witnesses. They didn't sit in the jury box. So how well a court can or can't do this is a matter of debate. Another standard is the one that I talked about earlier, but it's used in a different context here, whether there's a substantial probability. I talked about the substantial probability standard and what it was, that the error affected the outcome. Now here what we're saying is this applies to violations of the right to counsel. The lawyer did not perform, the lawyer was deficient in the performance. But then the court asks, is there a substantial probability that the outcome would have been different even if the lawyer had done all the right things? And if the judges sitting there decide no, then they'll affirm the case even though the person's lawyer did not perform adequately in representing them. The same thing is true for the discovery or the withholding of exculpatory evidence. The prosecution has a responsibility to turn over evidence that shows innocence. If the court finds that that's not done, the question it's going to ask is there a substantial probability that that evidence, had it been presented to the jury, would have affected the outcome? And if the judges can shrug their shoulders and say, no, we don't think it would, then they're going to affirm that conviction even though the prosecution withheld the evidence. Finally, just to mention it, the other standards applies to non-constitutional error in the federal courts, which is whether the error, whatever it was, had substantial or injurious effect on the verdict. This is also the standard that the Supreme Court adopted for habeas corpus violations, that if there's a habeas corpus violation, we don't ask is it harmless beyond a reasonable doubt, but we ask whether there's a substantial or injurious impact on the verdict that was decided. One last thing on harmless error. Some errors are never harmless, structural errors. One is racial discrimination. If there's underrepresentation of people of a race, or ethnicity, or gender in the jury pools, the question is not going to be, did it make any difference in the trials? We'll never be able to know that. One reason why it's automatic reversal, never harmless. When jurors are being struck, when they're picking the jury, if it turns out that the striking is on the basis of race, then that's going to always be deemed prejudicial, and so there's no harmless error applied to that. Any kind of race discrimination that takes place. Complete denial of the right to counsel. This doesn't happen very often, but there have been cases where judges have interfered with a lawyer's ability to communicate with a client, and in those situations, courts have held that that's a violation of the right to counsel. There's no way to figure out how much damage it did or not, so it's never harmless. It's automatically going to result in reversal. Denial of a public trial. Not too long ago, the court reversed a case called Presley versus Georgia, in which the judge, during the jury selection, told the people in the audience, you're going to have to leave the courtroom while we're picking the jury because there's not enough room for everyone in here. The lawyer objected, raised it on appeal to the Georgia Supreme Court, and the United States Supreme Court said constitutional violation. A defendant has a right to a public trial, and if that right is violated, the defendant gets a new trial. Because again, it's virtually impossible to assess what difference it made, but this is such a basic and fundamental right that it's going to be automatic reversal. Absence of the defendant from the trial. Sometimes things go on, the defendant hasn't been brought over from the jail, or for whatever reason, if the defendant's absent from the trial, that's never going to be harmless error. That's going to require a new trial if that happened. And finally, denial of an impartial judge. Again, hard to know whether if a judge is not fair and impartial, the rulings were right or not, but the court has said this is a basic right that people have. And so if there's denial of an impartial judge, that's going to require reversal in cases. So you look first at these errors to see, are they structural errors? Those are going to be easy, assuming you can prove them, which is often not easy. Or are they errors which are subject to a harmless error doctrine? And if they are, what's the harmless error doctrine that applies? Well, I know this is a lot of technical information, a lot of procedural information, but it's critically important in these cases because whether people prevail on having their death sentence or their conviction set aside is often going to depend on procedurally, whether it was properly presented to all the courts, the state courts, the federal courts. It's going to depend on who has the burden of proof very often. It's going to depend very often on what the burden of proof was. And even if a constitutional violation is shown, there are going to be harmless error standards applied that are going to perhaps make it possible for the court to affirm a conviction even though there's been constitutional error. We'll see all these things coming up in the materials that follow.